When you're playing defense, you have to be strategic. Sturmer's defense has not been. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. Midway through the day yesterday, the state rested its case in chief. The defense then argued that the state had not met its burden, that they should receive a directed verdict. It's standard. It doesn't really mean anything except in an exceptionally close case. That's because a directed verdict is a requirement if you're going to later suggest to the judge that you're deserving of a judgment notwithstanding the verdict, essentially asking the judge to sit as the 13th juror. There has to be a complete failure of evidence on at least one important element of the case in order to get that, and try as they might, they couldn't manufacture enough doubt in the judge's mind to get her to direct a verdict, which was obviously a very good result for the state. But then it was the defense's turn to put on a case as they had promised. I'm not really sure they understood the assignment. Several years ago, I tried the case against a nursing home. It was a case where they had let the lady lie essentially on her own, didn't see her. The nurses didn't see her for 26 days. In evaluating my evidence, I felt like it was necessary to have good experts who could support my case, and I had two very good experts. One was a nurse, the other a physician. I thought they did a great job. The other side had one doctor who was, in my opinion, clearly a liar. We played in court how he told doctors in a conference to document everything and then excused the failure of documentation in our case. So when he was talking to doctors, he told them one thing, and when he was talking to juries, he said another. I thought that the doctor was the best witness they had in that case. I thought that the case rose and fell on that doctor. It's very easy when you're evaluating a case to evaluate improperly, to let your biases invade your mental processes and not be as objective as you need to be. If you do that, you tend to undervalue the evidence that actually does hurt your case. And I think that's what I did in that nursing home case. They had a witness, a nurse's aide, who came in and testified about how much she loved that patient and how nobody in that nursing home would ever have hurt her. And they never ignored her. And she saw nurses in there every day that she worked. And of course, the actual record showed they hadn't seen the woman in 26 days, but the nurse's aide absolutely sold that line of baloney. And she stood up pretty well to cross examination. I'm sure they gave her a raise after that. The point is, I underestimated the value of that evidence, and I met it with medical evidence instead of with common sense evidence. Ultimately, I lost, and that was the reason. It takes a lot of introspection to really get to the end result of why you lost. But if you lose as a trial lawyer, you need to figure out why, because otherwise you're going to do it again. Well, it really stinks to lose a case, and when someone's life and freedom are on the line, it stinks even more. In the Sturmer case, the defense has made some bad calls. You have to establish reasonable doubt on at least one element of the state's case. That means you have to be careful and work hard at that, and you have to put up evidence that rebuts the weakest points of the state's case. In other words, if the issue is premeditation, for example, you have to put up evidence that shows there was no premeditation, that it was sudden or whatever, sudden passion. And if you don't do that and you instead attack the strongest point of the state's case, that the knife was pushed in so hard that it went out the other side, something like that, then in most cases, you're not going to be able to convince the jury that you're right and the other side's wrong. And you're unlikely to put up evidence that directly attacks their strongest point, which in this case is the medicating of Todd into unconsciousness and dousing him with gasoline. Their expert fire inspector cannot take that on since he was never at the scene of the fire. But the witnesses generally are not scoring points. One of the first bad calls was this witness.
You.
Yes, thank you, Your Honor. Ms. Gray, would you explain how you know well, let me strike. Do you know the Sturmers?
Yes, I do.
Do you know Mr. Todd Stermer?
Yes, I do.
You know Linda Sturmer?
Yes, I do.
Now, she was examined by Captain Oblivious, who went through a line of questioning that really meant nothing until he got her to the point where she stated her ultimate conclusion.
Do you know Mr. Todd Sturmer?
Yes, I do.
You know Linda Sturmer?
Yes, I do.
Ms. Griggs, prior to January the 7th, 2007, which was the date of the fire, when was the last time that you were at the house?
I believe it had been about 4 weeks.
About 4 weeks?
Yes.
Okay. And when I was asking about the conditions of how you, I'm going to say, how would you describe the unfinished parts of the house? Did you ever see any smoke detectors installed in the house?
No. There was holes cut in the ceiling, and you could see wires hanging down, but there was no actual smoke detectors. And I remember this clearly because I was court ordered to take a video of the house in a custody battle with my son's father. And he wanted to be able to see where my kids were being watched at. And the house was unfinished. There was no smoke detectors. And I never made the video because he would have eaten me alive with it.
So you had actually seen every part of this house?
The only part of the house I didn't see any of the bedrooms.
None of the bedrooms?
None of the bedrooms. Never been in any of the bedrooms.
But all the other rooms, the basement, you didn't see. You said had there been any attempt to place fire detectors in the basement?
Yeah, I remember there was a hole down there in the ceiling with 2 wires hanging out. Like it was set to put the fire detector in there, but it never got put in.
Okay. And that was the same way on the living area?
The same way, I remember the one in the kitchen as well.
That ultimate conclusion was, in my opinion, specious, a specious attempt to gaslight the jury. Because on cross examination, she admitted that the time frame when she saw smoke detectors was 2005.
When did you make a copy of this video?
I never actually made the video. I was ordered to make the video and decided not to because of the condition of the home. It would have been an issue in my custody battle.
When did you make it?
I didn't make it.
When did you see this? When were you going to make this video?
In 2005.
The fire was in 2007. More importantly, 4 people, the 3 sons and the brother of Todd Sturmer, all testified that the smoke detectors were installed and working at the time of the fire. Thus, the attempt to throw up somebody who was very close to Linda, close personal friend, someone that she'd known for 37 years, someone who had babysat her children, fell pretty flat, in my opinion. The next witness was the fire investigator from Detroit. Here, the defense is going to have a really big problem. The problem is going to be trying to explain how the state police investigator did his investigation at the time of the fire, was present on the scene, smelled the smells, smelled Todd's pants and smelled the gasoline, physically examined the site, physically examined those pants, walked all the way around, photographed from numerous places, looked at different sites where the fire could have started. That he somehow got it wrong, while this witness, who never went to the scene to see the fire or the results, but was working from pictures, somehow got it right. We start with this witness narrating his life history from the beginning when dinosaurs roamed the earth.
Mr. Mueller?
Thank you. Good afternoon, Mr. Trinkle.
Good afternoon.
I'm going to ask you some questions today about your work in this case. We'll just get into that in a second. Can you tell the jury what it is you do for a living? And then we'll get into how you and I got together on this case.
Okay. Yeah, I've been involved in the fire service since 1966. At that time, I became a trial firefighter for the city of Detroit. And I went through a 6-month training program. 320 hours were in theory, book learning, how fire propagates, how it progresses, and how to suppress it, and how the causal factors of it. And stayed in there, well, in 1967, the next year, 6 months later, we had a huge riot in Detroit and had innumerable arsons. So my goal was to be a fire investigator.
Fighter or the fire investigation expert, you've got special skill sets in fire suppression, tactics, and strategy.
Yes.
Tell us what background you have that makes you have subject matter expertise in that.
Other than college level classes, actual practical practical application, through the course of being in the firefighting division, I was mostly in a ladder company. There are fewer ladder companies than engine companies. We put aerial ladders up.
Now, after he put me to sleep with all that nonsense, I woke up with him discussing the scientific method.
What's the premise of the scientific method? Reliability?
It's one of them, yes, to come down to the truth of what happened.
Well, when we're talking about analyzing data, developing a hypothesis, testing the hypothesis, you see how it just kind of circles back and forth? It's an iterative process.
Right. As I said, you do it over and over again. I mean, it sounds crazy, but when you're going to a fire scene, in your mind, you're looking at building on the exterior and saying, well, I know it didn't happen over here, so we got to look over here. And in the continuum like that until you get down to the area where you can definitely define the origin.
In terms of the scientific method, you listened to Mr. Leroy testify last week.
Yes.
Would you say that collecting data is the most important step?
Yes. If you don't collect data, you can't analyze it.
And if
you can't test it.
You can't develop a hypothesis?
Correct.
Yeah. Would you agree with Mr. Leroy that if you don't follow each of these steps in a systematic fashion, then you don't have a reliable methodology?
Objector, I think he's leading his witness.
Did you hear Mr. Leroy testify regarding improper methodology?
I heard him testify to proper methodology and then improper methodology, yes.
Did you hear him testify regarding garbage in, garbage out?
I believe you asked him that question, or one attorney asked him that question, and he concurred.
And what does that mean to you as an expert?
It means you didn't properly do your investigation, and if you make a determination without having all of the information, your determination is invalid.
Okay. Unreliable.
Unreliable.
What would you say in terms of if your methodology is unreliable, what happens to your opinions?
If your methodology is unreliable, I don't see how you could make a reliable decision or conclusion.
So it really all starts with collecting the amount of data you need?
Objection, leading.
This is continued leading, Mr. Mueller.
What does it depend on to have an objective methodology? Where does it start?
Now, there's only one problem with that testimony, which is he didn't gather any data. He worked off of the photographs. He never went to the scene. He never did any of the things that he's now suggesting are, just terribly important in getting to the right conclusion. But he feels free to criticize the guy who was actually there on the ground. Hopefully, they'll address that in closing argument, but I think that's a really weak attack. Then, if that wasn't maddening enough, the guy can't answer a question. Listen to the questions and then listen to the answers, which are completely non responsive in most respects. Instead of answering, yes, I have an opinion, he goes into what that opinion is, which good witnesses are trained never to do.
Do you have opinions as to the quality of the documentation that Mr. Leroy did in terms of his excavation?
Okay, I'm sorry, misunderstood. There is very little documentation of what he did excavation-wise. There were some things that were, well, he declared the fire happened in the living room, and the living room's collapsed, so the evidence is in the basement level. And he moved some pieces of flue vent piping that I saw on the outside, and some furniture pieces, some springs and some framework.
Did you hear his testimony regarding how much of the living room he did?
He said he did all of it.
Did you hear his testimony about how clear the floor was when he was done?
How clear the floor was?
Yes.
Usually if you're talking about clear, you've hosed it off with, the assistance of fire apparatus or something like that. I don't remember him saying. I don't remember him saying.
Okay, so if you could try to just respond to the question that's asked of you.
He has criticisms about the failure to excavate, but I doubt that's going to ring very true with the jury. Although he hasn't finished his testimony at the time that I'm doing this, I can envision him being asked about the gasoline and whether it was more likely than not that gasoline played a role in the ignition of the fire. In other words, the defense is putting up witnesses that don't really matter in the long run. They are nitpicking, very much the way they nitpicked on cross-examination with the boys. They could attack them on their prior statements, but it was pretty clear from the testimony of at least one brother that they were essentially manipulated into lying.
Did Linda ever tell you what to say before the insurance depositions or before you spoke about what happened?
Yes.
And what did she tell you to say?
There were three things in particular that she wanted us to be on the same page about. She wanted us to downplay how severe the fight that night of the fire was. She didn't want us to really detail how severe that fight was, and it was severe. That was the most heated argument I'd heard from my parents. Second, she didn't want us discussing any talks of divorce to the insurance agent. And the most important one, she wanted us, if we were asked how we thought the fire started, she told us, say it was a chimney fire.
And it's worth noting that the defense attorney, I call him Kojerk because he has Kojak's haircut, but he acts like a jerk, had a difficult time on direct exam because the state was objecting to the form of his questions. He kept asking leading questions. When everything looks like a nail, you become a hammer. For the last week and a half, he's been asking leading questions of the state's witnesses. He's in that habit, and now that's what he's defaulting to. The judge had to remind him several times, and in this regard, I feel some sympathy for him because I've always had a hard time not asking leading questions. Because I know the answer I want to get, that's the question I ask. But I could never do that on direct examination, and of course, neither can he. Today, the defense will continue with this fire investigator, and it'll be interesting to see what his bottom line conclusions are. I guess he's going to say the fire was more likely than not started in the chimney, but of course, that doesn't explain how gasoline got on Todd Sturmer's pants. And at the end of the state's cross-examination, they're likely to ask how much money he was paid to come in and offer this testimony. In my opinion, this often hurts an expert, particularly if he doesn't know how to address the question. The expert should tell the jury, look, I'm being compensated for my professional time and not for my testimony. Of course, juries often don't believe that. They all believe that expert witnesses essentially are making money off of a tragedy. And sometimes they're not too far off. I can't wait to get to the jury instructions in this case and closing argument. I predict that the deliberation will go for at least 8 hours. That's because there's lots of evidence to evaluate. But I don't think it's going to make much of a difference in the long run how long they deliberate, because I can't see a reasonable jury coming back with any conclusion other than that this woman committed the crime for which she's charged. Let me know in the comments down below what you think the verdict will be. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.